Previously, we've already covered how in China. Let's turn to what happens when those rights are introduced, the typical enforcement options available in China, from customs seizures to civil litigation and even criminal prosecution. Each option comes with its own pros, timeline, and choosing the right one often depends on your goals and the strength of your evidence. Now let's walk through them. Let's start with the initial enforcement steps that are quick to deploy and often cost-effective. First up, the cease and desist letter. This is a formal notice to the infringer demanding they stop infringement within a relatively short period of time. Usually, when we issue a cease and desist letter, we'll demand them to take action. The letter typically cites your trademark rights or your IP rights under Chinese law and outline potential legal consequences if they don't comply. Although not legally binding, nowadays the cease and desist letter usually works, especially when the infringer is unaware that they are crossing a legal line. Actually, things are somewhat different in the past when the determination of IP protection is not that side in the past. I mean, in the past, I this letter to an alleged infringer, your evidence fixation work done, because this letter to the other side will serve as a effective warning them to warning them against your infringement, and what will quickly hide every infringement. The infringement maybe disappear for emerge again with a new entity name. So that's endless infringement. So in the past, I would rather recommend clients to directly to have the infringing evidence fixed by notarization, and then we'll have the option to file a civil action directly, or to try to file a cease and desist letter to establish a willful infringement, if that works. Second, in today's digital environment, online platform complaints, actually it's a very fast and practical option, especially for e-commerce infringements. Major platforms like Alibaba, JD.com, and even some trade exhibitions, they have takedown mechanisms. So with proper proof of trademark ownership and infringement, of infringing listing, and with 48 hours, so it's quite effective. Beyond the initial holder in China typically have three main formal which are administrative complaint, civil litigation, and criminal litigation. Let's talk about the administrative complaint. Owner, you can file a complaint with local IP bureaus targeting counterfeit production or sale. Seize the goods, infringing goods, and issue penalties to the infringing party. But this penalty, it's not the same as damage award. You won't get any damage award in administrative actions. So if your goal is to get a monetary compensation, then administrative action might not be the one for you. Administrative action, you will need prima facie evidence, a complete complaint form. This route often proves to be relatively quick, usually in about 1 to 3 months from filing to conclusion of a case, 1 to 3 months. So it's relatively quick, but this generally only apply to straightforward counterfeiting situation. If a trademark similar issue has to be determined, like be that suitable for pursued administrative complaint, because the administrative authorities will be against a likely infringement, not a 100% infringement. Well, secondly, we have the civil litigation. It's a widely courts here in China can award damages to up to 5 Chinese yuan for willful infringement. This is basically your go-to path for both stopping infringement and seeking monetary compensation. And thirdly, we also have criminal prosecution, but I'd like to say that not every trademark infringement case constitute or meet the entering bar, the threshold of criminal prosecution. Under criminal law, criminal liability applies in 3 main situations, which is counterfeiting, knowingly or forging or selling trademark labels. And the act must be intentional, involves an identical registered trademark, and used on the same goods, and meets the threshold for serious circumstances standard. This standard typically based on illegal sales or profit amount. If a case can be classified as a criminal case, penalty years to 7 years in prison. So it's depending on the severity of the case. And lastly, businesses are having OEM arrangement here. Touch on a very tool in China's IP enforcement landscape, especially for OEM custom enforcement. And even though your product is not manufactured here in China, it have a very good chance that your competitors and exporting them to sales markets that overlap with yours. Here in China will give you a way to intervene early at the border with a relatively predictable outcome and manageable cost. The mechanism allows trademark owner to stop infringing goods at the point of import or export. So once your trademark is recorded with Chinese customs, the custom officials are empowered to monitor and seize suspect counterfeits before they leave the country. So there are 2 main ways Chinese shipments, which is ex officio and upon request. We'll briefly touch on both ways. So first, the ex officio seizures means if you have your trademark registered and have your trademark recorded with China's General Administration of Customs. So the effect is nationwide. You or IP right with Chinese custom, and infringing goods are exported from any given ports within there's a good chance that the custom officer notify you that there is a batch of infringing. And by that time, to apply for a formal seizure and pay a bond. And if you do, the Chinese custom will start an investigation, completed within 30 working days. If infringement, most likely be destroyed. If not, they will be released. So the workflow, the general workflow of an ex-official request, custom detention request. This slide, the second slide, represent the second ways of custom seizure, which is by request. This is under the assumption that you have a registered right here in China, but you don't have that registered right record with the Chinese custom. So that's the condition. So under this condition, if you know a specific suspicious shipment, you can still possible to directly apply to custom to make to stop it. But you need to submit your IP certificate, the shipment detail, ranging shipment, and also pay a bond. After the detention, you will have 20 work court order, such as preliminary injunction. So that means you must take the case to court. Otherwise, if no court order comes in this custom, the custom will simply have to release the goods. You can see rights with Chinese custom makes a real difference when it comes to the bond amount required for seizure is dramatically record. For record rights, the maximum bond is kept at 100,000 RMB. So which is about I think it's about 20 less than 20,000 US dollar if I don't miscalculate. But on the other hand, if your IP is not recorded with the Chinese custom, the story is very different. You must provide a bond equal to the shipment's value. So sometimes this may go to hundreds or thousands of dollars. Otherwise, the Chinese customs won't act against the alleged infringed goods. They'll simply just release it. This issue, the bond issue, can be a serious obstacle, especially for small and medium-sized company. They typically don't willing to spend that large amount of seizure happen. Speaking of this bond, the timeline, it's not very sure, because only with the Chinese custom can the bond be after deduction of any fees from the custom. For example, if the is destroyed and the custom typically need to commission a company to destroy the goods. So some kind of handling fee will be applied to the right holder. Yeah. Um, there are there are another advantage of having your IPRI record with the Chinese custom. It's uh, they will unlock proactive enforcement from the Chinese custom, because the custom officer can detain suspicious goods on their own initiative and notify the right holder. In fact, over 90% of the infringing shipments are intercepted this way, and recordation is what enabled that. In contrast, if you don't record your IP right with custom, Chinese custom cannot act unless you identify the shipment and file a request with a full large amount of bond. So that makes things very difficult. And also, with the custom, it streamlines the procedure, because the custom already have your IPR record in their system. Your IP right a suspicious shipment very quickly, which speeds up the detention into early settlement. Finally, the recordation has preventive value as well. It's publicly available, so it signals it signals enforcement readiness and deters potential infringers in a sense. So to summarize, IP recordation with Chinese custom is the key to unlock efficient, lower cost, and proactive a OEM heavy business here in China. And yes, that's pretty much the all the presentation I have today. And thank you very much for your interest in this topic. And yes, I think we are ready to take some questions if you have any.
Thank you, Rick, for your presentation. It was really interesting to see how actually the customs authority works in China. So we're just starting the last section of a Q&A session. I don't know if anyone has any questions. If you don't have any questions to share, you can, of course, send us over an email, maybe to Rick or maybe to my email, so we can share with you our insights for any questions that you may have or our comments. So yeah, I think that
sure. It is also okay.
Yes, sorry.
Yeah, no. I was just saying, if you have any questions, you absolutely feel free to contact me through email or connect me in the through LinkedIn. Just search my name. You'll find me. Yeah.
Great. Well, Rick, thank you for your time again. Thank you for all of you that joined us today for the webinar.
My honor.
Navigating brand protection in the Andean community in China. It's been a pleasure to share all this important information with all of you. Thank you again, Rick, for sharing all your experience and insight throughout this session. It was a really detailed presentation, so we're thankful for that. And well, Queenie is not here, but I'm sure she's gonna watch the record of this webinar. Well, thank you,
sure,
Queenie, for making this webinar possible as well. Well, we hope you found the information helpful, and of course that it boosts your understanding for trademark registrations, dispute resolutions, and enforcement strategies in order for you to protect your brand in China or the Andean community. If you need any advice, of course you can contact me. at Union Andean, or you can contact with Tam at the F1 IP Law from China. We're here to help you. So thank you again for your time and participation. And we look forward to seeing you at future events. Well, have a great day. And in your case, Rick, have a great evening.
Yes, likewise. Thank you, everybody.
Hey, take care, Rick.
Thank
See
you.
you.
Thank you.
Bye.
Have a good one. Yes. Yes.
Bye.
Ciao.